Yeah, so I'll be talking about the Tilikum case. Just as a show of hands, how many people are familiar with this case? Wonderful. Okay, so I'm not going to go into a lot of detail, but certainly ask questions if I skip over anything that makes it confusing for you. I like to start with pictures of orcas as they should look, rather than as they look in captivity, as we talk about their captive situation. So I'm going to be talking about the lawsuit that was brought by PETA on behalf of Tilikum and 4 other orcas. And then I'm going to be talking about, because the way in which I think of this case now is that it doesn't stand on its own as a piece of litigation, but rather its impact and effectiveness comes from 2 other factors as well that I'll be talking about. And so then I'm going to try to look at how we can assess some of the impact of this work and lessons going forward. Okay, so this is Tilikum in captivity. Tilikum was taken at the age of 2 from waters outside of the coast of Iceland in 1983. And many people are probably familiar with the Shamu shows at SeaWorld. And so Tilikum was one of 20 whales called Shamu performing around the world for SeaWorld. My involvement in the case was as I was directing the Animal Law Clinic. So Jeff Kerr from PETA Foundation, who brought the lawsuit, and his team reached out to me and other advocates around the country to see if we wanted to participate. And so my students and I agreed to participate. We helped with the research, with the writing of the complaint, and we wrote a brief to support the work. I want to note, and we can talk about it later if it's of interest, that so this was happening in 2011. That some of my students were mocked for their work on this case, even by some of those peers at Lewis and Clark in the animal law community. The reason I mention this is because there are differences of opinion, right, about strategic directions. And so when you bring a case like this or work on a case like this, we have large conversations, right, that we need to have about why we're bringing these cases, what the risks are. And so we had those conversations, and we could talk about that more. Working on this case, something I had been paying attention to was the lack of attention paid to aquatic animals in particular. So this just spurred me on further to create the Aquatic Animal Law Initiative, which is now the Aquatic Animal Law Project at George Washington University. Okay, so a quick case overview. So this is a suit that alleges that involuntary captivity is in violation of the U.S. Constitution's 13th Amendment. The evidence showed that the animals were made to perform, to breed, and were kept in unnatural and unhealthy conditions. The named plaintiffs were Tilikum and Katina at the Orlando SeaWorld, Corky, Kasatka, and Ulysses at the San Diego SeaWorld. So Tilikum was involved in the deaths of 2 trainers and potentially a 3rd person who was a trespasser found dead in his pool. And so Tilikum was a particularly notable orca, right? There was a lot of press around him, and we'll talk more about that in a minute. The 13th Amendment in the United States is very, very simple. The only part you really need to pay attention to is neither slavery nor involuntary servitude shall exist within the United States. It's an unusually written amendment to our Constitution because it's self-enforcing. You don't need statutes, right? You don't need anything else. It's just, this should not be happening. So if it's happening, you have a cause of action, right? And so it doesn't say who shouldn't be enslaved. It doesn't say what kind of harms you have to prove from enslavement or from involuntary servitude. It just says it shouldn't be happening. And so therefore, if it's happening, the theory is it should be stopped, yeah? That was the thesis going in. We know also that this was designed to protect people, human beings, who had not been deemed legal persons. So it seemed appropriate to try to extend that concept of legal personhood, or at least enforcement of this, to a category of other beings who were not deemed legal persons. We know in the US that includes ships and corporations, as has already been said. And we also know that there was no other way to achieve this goal. There were no state or federal statutes, right? There was nothing else to enforce to bring this claim. So the suit was brought in the name of the animals, and I'm mentioning that because it was unique. There were a couple of other cases that might have been said to be brought in the name of animals in the US at that time. There were environmental cases brought for endangered species protection, And they really weren't being brought on behalf of the animals in the same way. So this was the first time we were asking a court to actually acknowledge that the animals were the plaintiffs, right? So we as litigators often have to say, well, we're harmed as humans because these animals are harmed, and therefore we have standing and we come into court. This was saying, no, this is the animals bringing their own case, okay? We didn't know if it would be kicked out immediately because of that, and it wasn't, so that was good news, right? We were happy about that. So I've said it applies as a ban on the types of activity. We don't have to focus on the category of victims. And if it worked, right, it would create this standing opportunity for many victims. Okay. Also, importantly for the case, we weren't seeking monetary damages. We just wanted injunctive relief to stop the behavior and rescue the victims. So as I said, this was a controversial case. Lots of people were saying maybe this was a bad idea. It would hurt other legal strategies at the time. Lawrence Tribe is a well-known constitutional scholar in the US and wrote before the case went to hearing and supportively of the case and sort of responding to some of the critique that the case had received, saying that people may well look back at this lawsuit and see in it a perceptive glimpse into the future of greater compassion for species. So that's nice. And basically, even if the lawsuit fails, we should be having this conversation. And also saying it would be a novel claim, but not a frivolous claim. So that sort of responds to some of the critique. But more importantly, he says, some may think it bizarre or even insulting, because some people did, to invoke the 13th Amendment in support of the claims of entities other than human individuals. Some may even be offended by the implied comparison of human slavery with the experience of non-humans who are captured in the wild and kept in conditions that are unnatural for the species. But that reaction would overlook both what we have in common with other species and the many respects in which the Constitution is essentially an aspirational document. So this was really helpful, right? Because we wanted to be very sensitive to the civil rights community. We had civil rights attorneys who had worked on, in fact, the Loving v. Virginia case, which we, if you're interested. So we were trying to make sure that there was harmony, right, between animal rights and human rights as we were positioning this case, right? That we weren't being offensive, we weren't being insensitive, but that we were still trying to say, there's an expansion possible here, and there's a way to do it respectfully. The court, of course, disagreed, but they didn't disagree substantively, right? So the case was lost basically on standing grounds, which we thought that it would be, and basically said the 13th Amendment only applies to people, right? And so you can't come to court. However, we were very unsure how the judge would react to this case and how it would be resolved, right? Because at that time, at least in the United States, many judges would sort of make fun of animal cases, right? The language would be very dismissive, demeaning, and even sometimes in positive cases, they'd use this really cutesy language, right? That was very inappropriate. So here, the judge took it seriously. He said, even though the plaintiffs lack standing, the plaintiffs being the animals, okay, I was very pleased by that, have no standing. Basically, it's not to say that animals have no legal rights, as there are many state and federal statutes affording redress to plaintiffs, including some instances. Now, really interesting, I find this interesting, because the judge was saying there are other ways to do this. Well, in fact, there weren't, so he's just mistaken. But I think this gets to a little bit of the thick and the thin rights, right, that Raphael was talking about, and a little bit to Kristen's comment earlier, the question about strategic, right, and whether we can be strategic while also asking for exactly what we're asking for, which is acknowledgement of the issues the animals are facing. And here I think we're trying to do both. And the judge, when he said that, I was like, I want to have a conversation with him about what rights he thinks already exist. So on the one hand, I think he was wrong in overstating it, but on the other hand, he didn't seem like that would be a problem, right? The concept of animals having rights was not problematic for him. And that, too, I think, was innovative and helpful, right? And so he also said, so the next friends, right, were the people sort of bringing the case. Their goal is laudable, but there's no relief for the plaintiffs. He could have said a lot of other things, much sort of nastier things, right? So in my view, this was successful, right? For other reasons that I'll talk about in a minute. So because the case was heard as a summary judgment, right? Basically, SeaWorld saying, we don't even have to argue this substantively because there's no standing, right? So we expected that, but it means that all of the facts that we asserted had to be deemed true. And that was the posture we wanted the case to be in, right? So we had a very rich record, factual record, of how these animals were harmed, right? We had experts, we had witnesses, we had veterinarians, it was, it's a hard read, but there's a lot of data that's unchallenged, right, in the federal court record. And we thought that was an important step as well. So we've talked about the focus not on the human harm and the judge's nice sort of attention to it. It was also important that the judge not find that it was frivolous, and the harm that some other folks in the legal community were worried about to their own legal strategies, of course, did not happen. And so that was something we were very attentive to and really grateful to see. It also made clear, right, that we could go to legislatures and say, all right, well, the court has said we can't use this, and basically come to you, so we're coming to you now, right? So there are no litigation avenues to protect the animals. So that helped a little bit with the legislative strategies that followed. Okay, so as I mentioned, there are these intersecting factors around this case. So OSHA in the United States is the Organization of Safety, Health, I'm saying it wrong, Occupational Safety Health Administration, right? So that's about health for workers in a work environment. And then the Blackfish documentary. So in 2010, Tilikum killed a trainer, right? People are familiar with this situation? Okay. So he killed the trainer during a performance, so in public, right? It was very well documented. And so the Occupational Safety and Health Administration said, okay, well, clearly there was a problem with safety, right, at SeaWorld. As legal advocates, we were like, wow, we never thought about using that. Like, brilliant, right? It didn't come from us, it came from them. So they did fine SeaWorld, and at the time it was one of the largest fines, $75,000, not a very large fine, especially for a death. SeaWorld appealed it, it was reduced to $12,000. Not much at all, right? But still, a sort of new legal strategy is born, right? So that happened before the case, then the case happened, and then shortly after the case, Blackfish, the movie, was released, which got immediate sensational sort of views, right? So 12 million views within the first, I think, couple of months. It's still #1 apparently on Netflix, and the New York Times has called it one of the 10 most influential films. So a little bit more about the OSHA relationship to this case. So SeaWorld not only appealed the amount of their fine, they appealed the fact that this should be reviewed at all. The review commission refused to hear that, which was good. The sort of first response was, okay, in order to protect the trainers in these situations, there should be some abatement, some protected contact rather than free contact. And we thought that's, as legal advocates, what we were going to be focusing on, right? We're going to have to figure out what does that look like and managing and enforcing that. And then SeaWorld didn't even want to comply with the follow-up to see if they were doing the abatement correctly. And so they had to be sort of, there was a petition filed against that. And then they filed a petition saying, well, we need more time to in fact do this. And then we're just going to appeal the whole decision again anyway. And their attorney was Eugene Scalia, who was the son of a then sitting Supreme Court justice, which you might think had some import, right? That case was argued in 2013, and gratefully the U.S. Court of Appeals for the D.C. Circuit, which is an important court in the U.S., upheld the ruling against SeaWorld in 2014. Interestingly, that ruling came down from Judge Merrick Garland, who some folks may know that name, and Judge Judith Rogers, and then Judge Brett Kavanaugh dissented. He thought SeaWorld should not be held accountable. May not be surprising. So there was a lot of litigation, right, following the initial administrative finding. So trying to figure out how to assess the impact of these three intersecting factors is challenging, and I think we could do well by doing some data analysis about that. We can't fully isolate those factors. But I also think the way I teach this case now to my students is we shouldn't seek necessarily to separate them, right? We should understand how things work in the real world and try to figure out how we can collaboratively work, right, so that litigation is lifted up through these other means as well, supported by these other means as well. So the social conversation I wanted to just highlight, so in 2010 when the OSHA fines came out, there was some press because This resulted from a whale killing a trainer, right? And that was pretty sensational. But in 2012, when the lawsuit was filed, global press, it was really shocking. We didn't think there would be as much press as there was. So that was really wonderful. And then Blackfish went just blockbuster, right? Okay. So there were additional OSHA fines after in 2015. Now animal advocates are thinking about these strategies. SeaWorld Orlando, which is where Tilikum was, had significant impacts, right? The park attendance dropped dramatically. The entire music sessions for the summer, all of the musicians, every single musician who was booked to perform that summer dropped out. The stock price fell. And in fact, because the park misled their shareholders about the problems, they got an SEC fine, so that's the government agency, and then they had to pay $65 million to their shareholders. There were also, Kiara, who is the last SeaWorld orca born in captivity, and she died at 3 months old. The new SeaWorld park in Abu Dhabi does not have orcas. So they could, because they're not bound by some of the regulations now in the US, but they have decided not to, but they do have dolphins. We've heard a little bit about things happening in Canada, and so the Ending the Captivity of Whales and Dolphins Act was put into place in 2019, and in France there was a ban on the breeding, importing, and captivity of whales and dolphins in 2020. Sadly, Tilikum has died, but there's still reporting about this case, right? As recently as July in the National Geographic, with quotes from Delcy Winders, who is here, and others. In California, just after all of this, so in 2014, a bill was introduced. It didn't pass until 2016, but really briefly, just to say that in California, you can't hold new orcas at all in captivity for any purpose. The ones who are already held are allowed, but they can't be used for entertainment performances, and they can't be bred, right? So this is very significant. We can talk some about litigation if you're interested. Lori Marino had a wonderful webinar sort of looking back at 10 years after the Blackfish movie, and that's online if you want to see it. Really helpful to think about it from both the journalist perspective and the folks involved in the movie. So some lessons quickly. So in my view, there's no one right way to take these cases, right? Or what cases to take. I think so we need many approaches. We need many legal approaches and non-legal approaches as well. We're looking for structural changes in the law. We have to pay attention to evolving science here, because the more we can help courts and legislatures and societies understand the biologies of the animals, right, the more that will help. And it's important to have these conversations. We can't say we helped all of the orcas that we would have liked to until Tilikum died in captivity, but we do think we're helping. This has helped other animals. It's likely helping the Lolita case, which we can, Lolita Tokutai case. And I think it's also affecting the reporting. So people have heard the reporting about the orcas attacking the boats, right, off the southern coast of Spain. And they're talking about that, right, as assuming agency, deliberate and rational behavior on the behalf of the orcas. And I don't think we would have seen that before. So there's still obviously a lot of challenges. So the number of captive killer whales is still the same, right, as it was when this happened. And that's because there's more in other parts of the world, which is unfortunate. We can talk about the Tokutai efforts to move her to sanctuary. So the very, very good news is that her owners in Miami have committed to moving her to sanctuary, right, outside, which is what people have been fighting for years. So we can talk about what different ways there are to sort of move towards the end of captivity. I want to highlight that there's a double standard in assessment when we're talking about moving animals out of captivity. So there's very high standards for release. Is this taken care of? Are they going to be harmed in this way? We don't have similar high standards for captivity, which I think we should be calling out more. And we should note that China is engaging on a breeding program really actively. So the last things I want to talk about is sort of where does that bring us in thinking about rights. So this is a chart that I devised for myself because I was trying to get clarity about rights, right? And it's really challenging. And so what I have is sort of who are the people we're thinking, or the beings we're thinking about rights for? What are their capacities? And then I have what I call fundamental rights, right to life, freedom from abuse or unlawful imprisonment, And then citizenship rights, because the minute we talk about rights, people are like, oh, you want a dog to vote. It's like, well, that would be a citizenship right. So we could talk about which beings, right, and which rights under which circumstances. But one of the things that I think this illustrates, and we can talk about it more, there's a lot in here, I know, to kind of throw at you in a quick way, and charts are kind of reductive, but the capacities don't equate to rights. That's the fundamental point here, right? We have no consistency in how we grant rights. We say that we do, right? We say the animals can't have rights because they don't have the same capacities as humans, but when they do, we still don't give them rights. And when humans don't, we still give them rights, right? So we don't have an ontologically consistent or supportable framework for the recognition of rights, right, or the enforcement of rights. So my chart is just sort of presenting evidence that they're not predicated on capacities or the ability to exercise and this supposedly important concomitant responsibilities, right, that is argued a lot, and that is complicated, right, and inconsistent, but we need to be having a dialogue about establishing and enforcing rights. And so the analysis, I think, is helpful. Until recently, it would have been odd to think about corporations having religious rights, but in the US they now do, right? So we can be talking about these things, but we should be talking about them coherently. So as these areas of law continue to evolve, it may be helpful to focus on the similarities and differences among and between beings, and the bases for granting rights in order to develop a consistent, justifiable, and sustainable legal framework. Thank you.